help me with the pronunciation. Glasefa?
Glasefa, Your Honor.
Glasefa, thank you. Good morning, Mr. Glasefa.
Good morning. May it please the Court, my name is John Glasefa. With me is Richard Jensen, my partner, and together we're representing the interests of the Allamerica Insurance Company. I believe that this case presents to this panel for the first time the precise issue of whether or not the total pollution exclusion applies to the discharge of oil into the environment. As I was preparing for this case, I cast back over my own career, and I've been dealing now with pollution cases for insurance companies for 2 decades. Everything from the sudden and accidental exception to the pollution exclusion, definition of property damage, occurrence, differentiation between chemicals, trichloroethylene, and so forth. By contrast, this case, to me, is absolutely clear.
Well, the language of the exclusion, if you look at it, covers this without any ambiguity, doesn't it?
It does, Your Honor.
But the cases apparently have carved out this little niche that's talked about in the briefs where you can avoid this.
The last several years, Your Honor, there's been a lot of litigation concerning indoor pollution and lead paint and fumes, so forth. This everyday activity limitation, which I frankly do not agree with respectfully, has been part of the cases in the last several years. By contrast, this case is not an indoor pollution case. Just very quickly, in terms of the facts...
Before you get to the facts, and forgive me, does the exclusion here apply to both property and bodily injury?
It does, Your Honor.
Okay. So if we were inclined to look at the sort of indoor pollution, quote, indoor, the lead paint cases, which really are, almost, as far as I could tell, almost exclusively bodily injury. This is property, right?
Correct.
Do I have to pay any attention to those lead paint cases?
Well, there's two. It's a very good point you make, Your Honor. There's two. There's a carbon monoxide case,
right,
and there's the McFadden lead paint case.
Yeah.
Both of them involve bodily injury. I think the problem with that analysis is it reads out part of this exclusion.
Okay.
You don't have to get to it in this particular case. And just factually, as this Court knows, this is simply a matter of a leak in a line running from a 275-gallon vessel in a cellar to the burner. Apparently in 1994, when the McGregor heating company put in the new system, it did not encase the line as it was supposed to. There are a series of violations of local Lexington regulations. In any case, there was a leak. The owner testified in his deposition that he only knew about it when he was away and came back and the tank was empty. There was apparently a sump pump in a sump underneath the undisturbed concrete floor, and it was traced to 150 feet behind the house where all of the oil had migrated to. This Court and the appeals court has clearly held over the years, and in fact, before I forget, Judge Ponzer, just as recently as yesterday. Reported in Lawyers Weekly, decided a case directly on point, and with the permission of the Court, I will submit this pursuant to 16L. Jack Nascimento versus Preferred Mutual Insurance Company.
Well, it was only on point with respect to oil being a pollutant.
Correct, Your Honor. It didn't get to the, well...
I mean, the policy had to do with the premises, a business premises, any leaks on the business premises.
Well,
there's no claim here that the oil isn't a pollutant.
That's correct.
Okay.
And Judge Ponzer decided that case yesterday, and I will submit that. And clearly, oil has been defined as a pollutant and falls within the definition of pollutant. It is a liquid contaminant into the environment.
Under the current case law, which does seem to carve out, and I don't think it's an unreasonable carve out, certain kinds of releases that would happen in the ordinary course of people working in your home, for instance, vapors that might come up from some sort of installation or lead paint painted on your windowsills. If this, taking those cases though, if this leak had been In the course of installing the furnace, a valve was not properly put on the furnace, and the installer went home, and the next day was called back, and the basement had 2 inches of oil everywhere, damaging property and obviously requiring cleanup costs within the home. Would this be included or excluded?
That's a good question, Your Honor. That's a much closer case, because we get into a situation where there's actually pollution inside the house, and then we get into this indoor activities, everyday activities. I would argue that you need to look at the language of the exclusion. It is very clear. It was written in a direct response to CERCLA 21E and the fact that the exception to the pollution exclusion and all of that litigation. I would say, Your Honor, if push came to shove, my position would be that this does apply. Oil did leak. It did leak into the environment. Now, if it stayed in the house completely, it's a tougher case to make. But this is a case, it's a very small version of an oil discharge into the environment. It's a classic pollution case. This goes back as far as the Torrey Canyon to Exxon Valdez. In fact, there's litigation involving the King of Spain right now for the pollution incident off of the coast in the United States District Court. This is a classic pollution case with a very clear contract. This court has said many times that it will read sensibly the reasonable meaning of the terms. It will not ignore terms in an insurance policy. The point made in my brother's brief, several points, he argues circumstances. He argues intent. None of that matters in this. This is a contractual undertaking. McGregor Heating and Air Conditioning purchased a commercial liability policy. It did not purchase an environmental impairment policy. It could have done so. This policy came with this endorsement on it, and the premium was paid. Point one. Point two, this is a situation where they argue that, well, if there's no coverage for this, Mr. McGregor is in the business of installing it. What would he have coverage for? Coverage is illusory. We give some examples in our brief of this. There's a hostile fire exception in here. If he was putting in a new heating system and there was water leaking on the driveway and ice was formed in somebody's driveway and somebody was hurt. If there was defective work which resulted in consequential damages from a non-pollutant, there could be coverage under the liability coverage. This is a liability policy geared to general liability premises type protection. It is not a policy which was bought and purchased for environmental impairment.
And he could have bought such a policy?
I anticipated that question, Your Honor, and I do not know the answer to that at the time he purchased that. In the amicus brief submitted by the Complex Claim Association, they do say that. I don't know the answer to that, Your Honor. I can't represent that to you.
Cost would be enormous, I would think.
Yes, it would be, Your Honor.
Mr. Glasefa, most of what you've been talking about is the duty to defend on the oil discharge, right?
Correct.
What about the duty to defend on the lost rental income?
Your Honor, the lost rental income falls within the other part of the exclusion. The notice of responsibility and the remediation cost portion of the loss is excluded under F2A, request, demand, or statutory order. The rental income is property damage, which is excluded under F1. And the Weathermark Utica Hall distinction does not apply here. In the First Circuit's discussion of those cases, and Justice Ponser mentioned this, and Judge Ponser mentions this in his case yesterday, does not apply. There were specifically enumerated properties in that case. We would argue that the definition of property damage includes the loss of use of tangible property and the diminution of property, e.g., loss of rental income. So it's our position that the loss of rental income is excluded by F1, and the NOR statutory costs are excluded by F2A. Just a couple of final points. The only case that is cited by my brother, and I think it's one single case, and I believe it's the American States case, is really standing out there on its own. The Superior Court decision cited by the Superior Court in this case, the home
Store.
Yeah. I just frankly think the reasoning is incorrect. And just to go back to the reasonable expectations argument, I think when Mr. McGregor purchased this policy, he reasonably should have expected, had he read CG-09735, total pollution exclusion, that he would not have coverage for government-mandated remediation costs under 21E. 21E has been around for a long time, as well as any type of property damage which resulted as a matter of escape of pollutants into the environment. This court, the appeals court, has held in the Hanover, New England versus Smith case that oil is indeed a pollutant for purposes of pollution exclusion. Sure, the court has read the briefs, but I would ask this court to adopt what I think is excellent reasoning, in the Dryden Oil versus Travelers case, as well as the USF&G versus Burbeau case, which is a exclusion applies to lead paint chips in the soil itself. If there are no other questions, I think that's the argument.
Thank you, Mr. Guasetta.
Thank you.
Good morning, Mr. Nicholas.
Good morning. If it please the Court, David Nicholas, Nicholas and Phillips, on behalf of the appellee, Mr. McGregor. Unlike my brother, who's been arguing these types of matters for 20 years, this is, frankly, my first. It doesn't mean that I'm not passionate about the position, nor does it mean that I don't believe that our position is the accurate one and that Judge Kern's decision was the accurate decision. The first thing that I think we need to look at is the fact that all insurance contracts are, by their very nature, adhesion contracts. This Court recognized that back in the Gill case, in which many of you sat and assisted in the rendering of that decision. You most recently addressed insurance policies in the City Fuel case approximately a year ago, in which you did again acknowledge that you interpret policies in the light of the customs of the trade in the course of the business of the insured. And where an exclusionary clause, as is here, in an endorsement, not in the main policy, you have to not only interpret that strictly against the insurer, but the insurer bears a further burden of proof since it's not in the main insurance policy itself. This Court, in the Gill case, after first addressing the McFadden decision, or the McFadden case in 1992, distinguished in McFadden between industrial pollution and residential pollution. And what we have here is clearly residential pollution. And one of the issues that will be before this Court is whether, under the policy, the terms of dispersal and other damages are terms of art which this Court has determined previously, dispersal at discharge or release. That's what you said in the Gill case, and that therefore those would be ambiguous in some extent, and whether the dispersal or discharge exist if it remains on the property. We do not have any migration from this property where the fuel tank was located to any other property whatsoever. It all remains on one residential house lot. And all of the other cases...
But excuse me, with respect to that, there may be circumstances because somebody else, has standing requirements where it's migrated, but a total pollution exclusion, if this gas tank had been installed outside the house, would you be taking the same position, even though it's on the same property? So if somebody's got a 200-acre property and they order to clean it up because there's been no migration?
The answer, Your Honor, Justice, would be yes. I would say that it is not migrated onto other property. That is the classic environmental pollution situation that has been addressed by all of these courts in the past.
There may be circumstances where, because it's gone into an aquifer or something, it's migrated, but that doesn't. But certainly, the environmental protection state and federal agencies don't look at that. If there's pollution on a property, gas station or whatever it is, they come in and order remediation. And if there's a pollution exclusion an insurance policy which excludes pollution coverage, it's hard for me to see that that would not exclude, just because it hasn't migrated.
Well, I would disagree with the Chief Justice. What we have here in this particular instance is no migration off of a house lot. We're not talking about 200 acres. We're talking about a specific house lot. And
But where's the language in the policy that says it can't, that there's a boundary limitation?
the language in the policy doesn't deal with boundary migrations. What my brother argued in his brief was that if you're within the four walls of a building, that you have no migration, that you do not have a classic pollution. And I would suggest to the court that there's no difference between the four walls of a building and a property line.
Well, his problem is he's stuck with a couple of decisions that suggest that the four walls make a difference. You know, you've got fumes, you've got lead paint.
All of the cases that I located, and I believe all the cases that are cited by my brother as well, deal with migrations. When they determine that the pollution exclusion clause does apply, they deal with migrations of the pollution off of the site.
So if this had gone over to the neighbor's property, you'd agree this exclusion covers it, knocks it out?
I would suggest that I would have a higher
Tougher time.
a higher cliff.
That would
decline, yes.
seem to me to provide a huge incentive. Here what happened is, presumably because the owner of the house was concerned, and I don't know who called in the state environmental people, but I think it was the house owner, correct?
I don't recall who called
think,
in
yeah.
the Commonwealth. I believe it was actually the owner's own insurance policy that called it in.
Oh, okay.
But what we have is a situation, frankly, where my client went to that location once over 6 years prior to the particular incident that we're discussing today. And when you look at the context of the actual damage and the actual injury that is alleged to have occurred, you have this clearly brought in, I would assert, to the carve-out which this Court has set forth in the Gill case, where you have an everyday activity gone slightly, but not unsurprisingly, awry. This was normal work 6 years ago.
But that really doesn't go to whether the policy excludes it, whether it's normal or not normal, correct?
The policy language is very slightly different from before. There's very little change in the policy language from that existed in the Gill case. And I would suggest that the change in that policy language is immaterial. The pollution exclusion carve-outs by the courts have all been for the reason that they have recognized that the reason for drafting and placing in those pollution exclusion clauses into the insurance policy was to avoid the enormous expense of environmental litigation. The Navitt case that I cited in my brief has a laundry list of other cases, as well as the history of insurance companies placing these in order specifically to avoid the litigation from extended and costly environmental pollution.
Well, so what? That's part of their business. And, here it's an oil company that's putting this in, correct?
No, it's not an oil company. My client was not an oil delivery outfit. My
What were
client
they?
was an HVAC repair contractor who admittedly did not touch the fuel line. And this is a piece of line about 8 feet long or 10 feet long he didn't even touch. It was operating fine at the time, and 6 years and change later, finally failed. And this goes to, again, the question of whether or not the insurance company should at least be defending the particular lawsuit that has been brought against McGregor.
But the only thing for which your client has been sued are the remediation costs, am I correct?
No. The remediation cost as well as the lost rental cost.
I'm sorry, yes. But it hasn't been sued for the failure of the whatever system he put in place, correct?
The lawsuit alleges breach of contract as well as the recovery for remediation, as well as recovery for attorney's fees and other costs under 21E.
Was there some regulation that required your client to install a new, even, you say he didn't touch the line, but was there some regulation that required him to install a line that had a liner on it, like a double line?
There was a regulation that had just gone into place within the prior 6 months that did address fuel lines, and whether that applied in this particular instance, I'm not prepared to address the court today, but there was a regulation that did address that. And 21E, under which my client was sued in the underlying action, contains 5 separate categories of persons that could be responsible. And this is could be responsible under 21E. My client could possibly only fit one of those circumstances, and that would be the allegation that he caused or was legally responsible for the release of the oil from the vessel or the site. And to say then that the insurance company doesn't have to defend where my client denies that he was legally responsible in the first instance, defend the underlying action, I would suggest to you is ludicrous and does make the insurance policy illusory in that respect at the very least. And what we instead have is my client expending all of the costs and expenses for defending the matter itself. The real question is what, I believe, is what is environmental pollution? Is environmental pollution pollution that is controlled and contained on one house, residential house lot, or is environmental pollution as defined in the cases and as anticipated by my client at the time that he entered into this insurance contract, something that is much broader? And I would suggest to you that all of the cases that deal with environmental pollution deal with pollution that has been dispersed and usually directly as a result of the immediate action or the immediate past action of the party sought to be charged. And that dispersal goes beyond the boundary lines of the property owner. And it also deals with primarily, although not exclusively, with industrial, commercial operations, not a residential house. And what we have here again is a residential house.
What is the exclusion cover? There's a provision in your client's policy that says total pollution exclusion, correct?
There is.
What does it cover?
It's the insurance company that drafted that policy
but I'm just
and that
asking
exclusion, and I'm sorry, I would suggest to the court that what it covers is just that environmental pollution where you have something that disperses the pollutant over a wide area and not just on the residential property. We don't, the question is, what does disperse, what does discharge mean under the pollution exclusion clause?
Well, let's say your client's shop has his commercial shop has an oil tank, which provides oil presumably for heating and maybe even fueling the trucks or whatever is necessary, and that has a leak, and it leaks and doesn't leave his property but is on his premises. Would that be covered in your view?
Your Honor, Justice, we don't have that situation. My client is not an oil delivery person.
No, I'm not talking about oil delivery here. I'm just, all right, he's got a shop. He's an installer. He installs various forms of equipment, right?
That's correct.
So he's got a shop where he stores stuff. But there's an oil tank on the premises that heats the shop. And it has a leaky pipe or a leaky tank, and 300 gallons of oil are leaked out into the environment. But they don't leave his property. Would that be covered, do you think? Isn't that a classic discharge, oil pollution kind of case?
The definition of bodily injury, of the exclusion for property damage says that it does not apply to property damage at any premises, site, or location at which time was used by or for the insured for others for the handling and storage. So that would be under this, it would not be covered.
Okay.
Well, wait a minute. You say for handling and storage. This isn't, the hypothetical that was put to you wasn't a storage. It was use. He was using the oil not to sell to people, but using it to heat the shop.
I misunderstood the
Would it be, would that, if that leaked, if that tank leaked, would the leak be covered under the policy?
I would argue that it would, because you have to store the oil in a tank in order to have it available. There's a particular exclusion under the policy itself for any liquid gas. My client was not permitted under this policy, and he understood he couldn't go under this policy for liquefied propane. This dealt with only the installation of HVAC equipment for oil or coal or other types of heating units, but not liquefied propane. So in your example, the exclusion would not apply because it would be stored there on his own premises. I would like to address the McKinnon decision for just a brief moment, out of California, 2003 decision. And in the McKinnon decision, the court really looked at the questions of and the definitions of discharge and dispersal. And they said you have to look at Webster's dictionary for determination of what is a discharge and what is a dispersal. And I would submit to the court that if you look at those definitions, if whatever contaminants remain on the premises, you do not have a discharge or a dispersal.
Thank you, Mr. Nicholas.
Thank you.